Ms. Williams, good afternoon. If you go ahead and take your place at council table, make yourself as comfortable as possible. We're here this afternoon in the matter of State versus Brianna Williams, as present along with Mr. Beard, her counsel for the state. Ms. Anderson and Mr. Hutton are also present. This is 19 CF 11711, case 48 on the calendar. The matter was passed today to permit the court to review items that were submitted for its consideration at the second day of the hearing. After conferring with counsel, I, of course, committed to review all of the evidentiary exhibits that were submitted. There were in excess of 125 for the state, approximately 7 for the defense. I've reviewed them all, some in the company of counsel and some in my chambers. So that the record is clear, I have reread the pre-sentence investigation report subject to the objections that were raised by Mr. Beard. I've read the defendant's transcripts from secondary school in their entirety and I'm familiar with their content. I've read the defendant's entire packet of military records submitted for my review. That's Defendant's Exhibit 2, including all of the efficiency reports submitted by those who were responsible for her supervision in the Navy. I've read the Clinical Psychology Associates of North Florida report in its entirety as prepared by Dr. Bordini. That's Defendant's 1. I have read again for a second time the report of osteological examination submitted for the court's consideration, and at the request of counsel, I have also read the deposition of December 6, 2021, taken of Heather Walsh-Haney, PhD, regarding the analysis of the bones recovered at the crime scene. Having considered all these items, I spoke with the state and the defense at sidebar prior to you being brought out, Ms. Williams, and so I won't keep you in the dark about anything I ever say to your attorney or to the state. I discussed some real questions I have regarding the law, but I'm going to put those on the record here in just a moment. They may be inconsequential, but I wanted to warn the lawyers that they may be raised, and once they become part of the record, they may be an issue that the lawyers can help me with at some future date. But regardless, I'm prepared to go forward with sentencing today. It's important that we recall that the guideline range is 20.5 to life. The defense has argued for a minimum guideline sentence, recognizing that there's no legal basis to deviate below the guidelines. They requested that the court impose a sentence of 20.5 years. The state is seeking life. Sentencing is difficult for any judge. It's particularly difficult in a case like this. I've examined the mitigation that has been offered by the defendant. It's important to recall that we are here today on a sentence for second-degree murder. The defendant was originally charged with a series of crimes involving child abuse or neglect, as well as essentially providing false information to law enforcement. Those were dropped in light of the plea to the pending charge. She's not charged with those any longer, although child abuse and neglect became relevant. Her lying to the police became relevant.